Hello, welcome back to Norton Rose Fulbright's Restructuring Touchpoint video series. Today we will hit the offshore energy industry. I am David Rosenzweig, a partner in Norton Rose Fulbright's Restructuring Group in New York. We're joined by Eleanor Martin, who's a partner in the firm's banking and finance group based in London. Eleanor has immense experience and is a leader in advising lenders on offshore vessel and equipment financings across the globe. We're also joined by Kristian Gluck, who's a partner in the firm's restructuring group. He's based in Dallas. Kristian has been involved representing lenders in some of the most complex restructurings and reorganizations across the globe, including most of the energy and offshore shipping cases in recent years. What we're going to cover today are market challenges and the potential distress in the offshore energy space. As an example, we're going to focus on the recent Chapter 11 restructuring of Altera Infrastructure, which could be viewed as a typical cross-border offshore vessel group. And then we'll conclude with some lessons learned from that restructuring. So Eleanor, let's start with you as the expert in the industry. How does the industry look, and what do you see as challenges ahead?
Thanks, David. Well, the offshore energy industry has had a really hard time of it recently. A combination of lower oil prices, COVID issues, supply chain issues, and high inflation mean that new developments just haven't been getting sanctioned, or if they have been, they've been pulled due to all of these factors. And that's left the offshore service industry in a bit of difficulty because there aren't enough projects to sustain the amount of vessels that there are on the market. Combine that with the fact that there is a heightened sense of focus on greener energy and decarbonisation. And we're seeing a number of the financiers actually take themselves out of this industry and stop supporting some of those offshore energy companies that they've traditionally supported for many years. Having said all of that, it's starting to look a lot more positive now. We're seeing a renewed focus on energy security and people really starting to sanction new projects and starting to develop areas that they wouldn't otherwise have done so. So it's been a hard time, but we're coming towards a less challenging time, I would say.
Thanks, Eleanor. Let's focus on the challenges then and talk about some of the distress. Follow that thread. Why don't you tell us about Altera, how that looked at the capital structure of the business, and then we can dig deeper into that restructuring.
Sure. So Altera Infrastructure are a large offshore energy company, and many of you will previously know them as part of TK Offshore, but they spun out of them several years ago. And they have a combination of different types of assets, all operating in the oil and gas industry. And like many of the offshore energy companies, they had structured their financing arrangements through vessel or project financings. And so they had a series of secured lenders who were international banks, but also with some backing from export credit agencies, and there were 5 in this instance. And they had separated those financings into 7 separate silos, each with different vessels as collateral. And all in all, they owed around 550 million to their financing community. Again, like most offshore energy companies, they had a bond, an unsecured bond, at the parent company level. And over those difficult times we were talking about earlier, they'd enjoyed an awful lot of support from their sponsor. And that had resulted in a significant amount of equity and debt owed to their sponsor company. And they had several vessels which were on long-term charter with good oil companies, which were performing well. But they had a number of assets which just hadn't been winning those deals, largely because there weren't that many deals in the market to be won. And then on top of that, of course, they had the usual trade creditors. And the mix of their assets was actually quite interesting. So they had FPSOs, FSOs, towage vessels, accommodation units, and various other vessels within the group. And as a result of that, each of those different silos that we were talking about, those different lender groups, had different interests and different levels of performance under their loans. So given all of this, it wasn't very easy to see a path to a consensual restructuring when the company realized that essentially its debt stack couldn't be serviced by the amount of income it had through projects and vessels operating under charter. So it was tough to find a way through a consensual restructuring. But in the end, a restructuring was accomplished really quite quickly, sort of 11 months in total and less than 5 months within a Chapter 11 process. And their plan took 84 days to confirm. So it was a tough one, but they made it in the end.
Thanks, Eleanor. That sounds like a great result, but a lot of cats to herd. So sounds like a busy capital structure. Kristian, as the restructuring expert, how was that accomplished? How did Altera do it in such a quick fashion?
Thanks, David. Thanks, Eleanor. So as Eleanor mentioned, a consensual arrangement is what is preferred, and that's what the parties attempted to do here. It started off with the formation of a coordinating committee of lenders. We'll refer to that as the COCOM throughout here. And that was comprised of various lenders and export credit agencies. And then the COCOM helped facilitate discussion amongst the lenders that were not party to the COCOM. So the company would engage with the COCOM, the other secured lenders, the bondholders that Eleanor mentioned, and then the sponsor. And ultimately, through those negotiations, we entered into what we call a restructuring support agreement, or RSA. And in this case, it included 6 of the 7 silos. So you had one holdout and the sponsor. There are various sort of things that the RSA covers, but primarily, it deals with the restructuring of the facilities, the equitization of the sponsor's debt, and then it also has bells and whistles to sort of keep the parties to the RSA in line. And importantly, there were milestones in order to move the restructuring along as quickly as possible, in order to save cost and to get the company back in a restructured position so it can get out into the marketplace. Had term sheets for an in-court restructuring as well in the event that unanimous approval of the restructuring couldn't be approved or close to unanimous. And in this case, as Eleanor mentioned, we were unable to restructure out of court, and a Chapter 11 process was used here. Did have a couple of holdouts, as I mentioned. You had one of the silos, and then also the approximate $275 million of bonds. And given the fact that you had some holdouts and without the benefit of a stay of enforcement proceedings and maybe risk of termination of contracts, the company made the decision to file a Chapter 11 proceeding in the bankruptcy court in Houston, Texas.
Thanks, Kristian. It sounds like Altera started like many with the aspiration of a consensual out of court deal, but eventually had to go into a proceeding, and in that case, Chapter 11. And just talking about that quickly, Chapter 11, it remains the most popular choice, I think, for restructuring still. But there's more competition now with other jurisdictions getting in the game, trying to capture work and restructurings in their countries. So, for example, we know the UK restructuring plan has taken off. The Dutch have worked on their schemes and have a new structure called the HUA. We know Irish examinerships are gaining in popularity. And of course, in Asia, Singapore is trying to become a hub with new restructuring laws there. That all said, Chapter 11 remains the benchmark, and the out-of-court possibility or settlement is marked to what could be achieved in a Chapter 11, as is any other jurisdiction's process as well. So there are many, in many situations, other processes and venues are looked at now and considered, but here in the end, again, Chapter 11 was chosen for Altera. And getting a little more granular there, Kristian just mentioned Texas. Altera filed in Houston, Texas, the Southern District of Texas, which has become a very popular reorganization-friendly venue for Chapter 11, not only for the offshore energy and shipping world, but in many other industries as well. So, Kristian, let's turn back into the specifics for Altera, and in particular, why does Chapter 11, and why for Altera was Chapter 11 the go-to process again?
Thanks, David. Yeah, I'll highlight a few. I mean, you mentioned some of them as well. The worldwide automatic stay is a big component of a U.S. restructuring. It keeps creditors at bay while the company can sort of take a breath and figure out how to restructure without worrying about, creditors taking action to try to collect on their debts, pick up assets. Global banks and other corporations respect the stay because they have a presence in the United States, and they can be subject to sanction for violating the stay. As you mentioned, there's a long track record of Chapter 11. There's predictability in that. Parties are very comfortable with the process. They understand generally how it would work. At least, especially with the Southern District of Texas, the two judges. There's been a change recently, but Judge Isger who had the case, and then Judge Jones have been on the bench for a long time. Just predictability. It's helpful to your clients for them to understand how the process would work. The professionals understand it as well. And it also has a tool in order to sort of deal with holdouts, which we had here. And that's the cram down right. And that's the ability to take holdout lenders and sort of cram the plan down on them, even if they don't agree to it. We also had here the threat of giving the vessels back for the holdout lenders. Not sort of an ideal way to deal with the restructuring is to get your assets back. And then one sort of additional, I'd say tool in the toolbox now is the use of mediation. It's become very popular, especially in the Southern District, where the judges will mediate each other's cases. It's helpful to have a sitting bankruptcy judge tell your client sort of how things are going to go. It's just easier to you sort of land on a deal when you have a sitting bankruptcy judge telling your client, how the case is likely to work out. And the mediation sort of, cuts through a lot of the otherwise litigation that you would have. So it keeps the cost down, and it also shortens the timeline. And in this case, that was very important to all the stakeholders, was to get out of bankruptcy as quickly as possible. Eleanor mentioned it was 84 days. It was a fantastic result by all the professionals involved. And ultimately, we're able to get out of bankruptcy very quickly.
Thanks, Kristian. Yeah, that mediation is certainly a 1-2 punch down in Houston, where you have the one judge is your judge and the other judge is the mediator. So they really get to a result. Let's get back up to you, Eleanor, on the industry as the industry and finance expert here. What lessons should we take from all of this, from the Altera restructuring in particular?
Well, I think, as we talked about earlier, companies positioning themselves to take advantage of the market on its up, which it is now. And so for me, really, it's the cooperation between the different secured lenders and stakeholders involved, because it could have been a situation where those secured lenders chose not to use their collective bargaining power really to get themselves the best possible deal that they could get in this restructuring, and risk a sort of piecemeal liquidation, which could have been beneficial perhaps for some parts of the group, but not others. And so really that use of that COCOM as a coordination and a focus for negotiations to make sure that they were exercising their collective bargaining power to enable the company to enter into a process, but with the support of that RSA, which protected those secured lenders, as well as providing the roadmap through the restructuring. And then because in the end, 100% of the buy-in was not obtainable prior to filing, really using that court process to succeed in enabling that plan to be realized through the court process in a short space of time, and now leaving Altera Infrastructure in a stronger and better position, and hopefully able to go out there and win those new deals that we're seeing coming to market.
Thanks, Eleanor, and thanks, Kristian. That brings us to the end. That's Altera, but stay tuned for the next Norton Rose Fulbright Restructuring Touchpoint video series.